the solicitor's fees, and other recovery expenses as a result of the unlawful and willful action of the defendants. 3. Interest at the Central Bank of Nigeria prevailing lending rate on the said 14,365,200 naira from the first day of June 2022 till judgment, and thereafter at the rate of 15% per annum from the date of judgment until the entire sum is liquidated. The claimant, however, withdrew the claim of interest on the 14,365,200 naira from the first day of June 2022 till judgment, leaving the remaining claim under paragraph C intact. I'll go to the claimant's case. The claimant employed the first defendant on the 13th day of October and placed her in charge of its BYC exclusive shop at number 009 Oyo Plaza International Center for Commerce, Lagos. Her duties, among others, included receiving goods for sale from the company, selling them, and remitting the proceeds to the claimant through a designated bank account. The second defendant guaranteed the employment. The first defendant, just like the other salespersons in the claimant's employment everywhere, was under strict obligation never to sell the claimant's goods on credit. For that reason, only receipt booklets were provided to all the shops, including the one manned by the first defendant, instead of invoice booklets used by sellers who are free to sell on credit. This instruction was repeated from time to time as the claimant's overseas suppliers dealt on a cash and supply basis. During its 2022 July stock-taking exercise, the claimant discovered a shortage in the goods amounting to 15,365,200 naira. The first defendant's explanation was that she unilaterally sold the missing goods on credit to a customer who died before he could pay for the goods. She did not provide any details or documents about the customer or evidence of the transaction she allegedly made on credit. The first defendant admitted liability for the missing items and refunded the sum of 1 million naira to the claimant in 2 installments and begged for more time to pay for the goods. The second defendant refused to honor the summons to appear in this case. He also ignored the letters of demand. The claimant procured and tendered the Central Bank of Nigeria monetary rate between June 2022 and October 2023 when this action was filed. The defendant's case. The defendants were served with all the processes. No memorandum of appearance or statement of defense was ever filed by the defendants or the counsel who appeared a few times in court during the pendency of this suit. The first defendant, and through her counsel, kept promising to pay back the money or a substantial part of it before each succeeding adjournment. The court kept obliging the defendants since they promised to file terms of settlement. The defendants never made good their promise. Trial commenced on the 19th day of November 2024 and was concluded on the 21st day of January 2025. The claimant had one Mrs. Roslyn Martin, who testified as CW. She tendered 9 numbered documents as exhibits, which were admitted and marked as Exhibit C1 to Exhibit C9. The claimant's final written address is in the body of this judgment. I will go straight to the court's decision. After this case was instituted, the defendants failed to file any process, even though they were served with the originating process and all other court processes. The court in EcoBank versus Money, citation provided, held that litigants cannot ignore court processes or wish them away. Anyone sued to a court of competent jurisdiction is obliged, nay, constrained to appear to defend the claim or face the peril of being taken to have considered to the said claims of the claimant. When a claim is not challenged on time, unpleasant consequences may occur, particularly with our adversarial system of jurisprudence, where the judge is but an independent referee and is not party unless there has been a miscarriage of justice. The court proceeded to hear the matter by invoking Order 8, Rule 5, Sub 1, and Order 19, Rule 2 of the NICN Civil Procedure Rules of 2007 of 2017, which provides as follows. Order 8, Rule 5, and I quote, where a defendant or respondent fails to file a memorandum of appearance within the stipulated time or fails to file appropriate processes in defense of the action within the prescribed time and also fails to file a declaration of intention not to defend the action, the court may proceed to hear the matter and give judgment. Order 19 Rule 22 states where a cause is called for hearing and the claimant appears, but the defendant or respondent and or counsel do not, and no good cause is shown for the absence, the claimant may prove the claim insofar as the burden of proof lies upon him or her. End of quotation. By the decision of Umar versus Efium, citation provided, it is right that a party who was afforded an opportunity to be heard but did not make use of the opportunity cannot be heard to complain of a breach of its right to fair hearing. What is paramount is that the trial court must have afforded all parties equal opportunity to present or defend their cases. In the instant case, the defendant failed to file any process after he was served with all the processes. The court was convinced that the defendant was afforded a right of fair hearing, and the claimant thereafter opened the employment agreement dated 13th of October 2011 with the defendant marked as Exhibit OH1 to prove there was an employment relationship with the first defendant, and by the content prove the existence of guarantee obligations from the second defendant. In Norman M. Sylvan's Law of Employment, 4th edition, Bufferworth, London, 1982, page 153, it reads, and I quote, "Since the relationship between employer and employee is one of trust and confidence, the law implies into the contract of employment the term that every employee shall serve his employer faithfully. This is a fundamental obligation, and any serious or persistent course of conduct which is inconsistent with that obligation may amount to a breach of contract. The employee therefore undertakes to perform his duties carefully and competently with due regard for the interests of the employer." See Secretary of State of Employment versus ASLEF, 1972, 2 Queen's Bench 443. Bello Jazz SC in Niger Insurance Company Limited versus Abed Brothers Limited and another held that in Sterling Engineering versus Patriot, citations all provided, Lord Reid stated the legal connotations of the phrase implied terms in these words. Strictly speaking, I think that an implied term is something which, in the circumstances of a particular case, the law may read into the contract if the parties are silent, and it will be reasonable to do so. It is something over and above the ordinary incidents of the particular type of contract. If it were necessary in this case to find an implied term in that sense, I should be in some difficulty. But the phrase, and I quote, implied term, can be used to denote a term inherent in the nature of the contract, which the law will imply in every case, unless the parties agree to vary or exclude it. End of quotation. In every contract of employment, a term is implied that the employee will serve the employer in good faith and honesty. In holding that there was an implied duty of good faith in the master-servant relationship, Lord Esher, Masters of the Rule, said, and I quote, "It is impossible to suppose that a master would put a servant into a confidential position of this kind unless he thought that the servant could be bound to use good faith towards him." End of quotation. In the instance case, the claimant averred in his statement of fact, paragraph 5, that the first defendant was employed as a salesperson in the claimant's company. First defendant was to make sales, record, and remit same to the claimant. This she failed to do in paragraph 15 of the statement of fact. In paragraph 18, the claimant was issued a query on the 22nd day of July 2022. In a response to the query tendered and marked as Exhibit OH5, the first defendant admitted that in 2018, she sold goods on credit worth 3.7 million to a certain customer, and after paying, and I quote, installmentally, covering nearly more than half of the amount he owed, which gave him access to another supply of 2.5 million, end of quotation. However, in 2020, she got a call that the customer had died and she lost contact with his family. It is the case of the claimant that the first defendant was under instructions not to sell products on credit, and this act of the first defendant was in breach of his agreement. The first defendant did not deny this fact in Exhibit OH5, but stated that she was, and I quote, making a lot of effort to clear this debt as soon as possible. All I plead for is little extension, end of quotation. In view of the above admission of a breach of a duty to make sales, record and remit same to the claimant in Exhibit OH5 and OH7, it is tried that facts admitted are deemed established, hence there's no need for further proof. See Estate of Abacha versus AKSP, Okposin versus Assam, as well as Section 123 of the Evidence Act 2021. The claimant is therefore entitled to Relief 1, which is seeking for 14,365,200, being the balance of the value of the product missing under the trust, care, and management of the first defendant, which was guaranteed by the second defendant. I so hold. Relief 1 succeeds. Relief 2 is for 4 million general damages suffered, including slowed down for business, the solicitor's fees, and other recovery expenses as a result of the unlawful and willful action of the defendant. In NACB Limited versus Achagua, citations provided, the court clarified how general damages are determined. Thus, and I quote, one of the characteristics of general damages is that it is fixed by the opinion of the court, such as the law will presume to be the direct, natural, or probable consequence of the act complained of, end of quotation. Samoris versus Maja, Union Bank of Nigeria versus Ajabule, citations all provided. The claimant in paragraph 13 to 15 of the statement of fact pleaded that stock taking conducted in 2022 led to the discovery of the discrepancies amounting to 15,365.200 million, being the total amount missing, and from undisputed evidence, claimant proved the terms of the employment. The clear operational instruction and its flagrant violation were proved. In fact, this first defendant admitted liability for the loss and started paying back in installment before she stopped in 2023 till now. A total of 1 million naira has been returned by the first defendant. The queries to her and her responses are in line with the claim. It is tried that general damages are awardable per se upon breach, and it is compensatory in nature in monetary term, as assessed by the court in exercise of its equitable jurisdiction to compensate the injured party by the act of the breach of contract or injury inflicted. See Shuka versus Abubakar, citation provided. The court also noted that Relief 3 also has included the solicitor's fees and other recoverable expenses. On the whole, the claimant succeeds in Relief 2. The sum of 4 million naira is hereby awarded against the first and second defendant in favor of the claimant, pursuant to Order 55, Rule 145 of the NICN Civil Procedure Rules 2017. I so hold an order. For Relief 3, which has two arms, that is, interest of the Central Bank of Nigeria prevailing lending rate on the said 4 million from the 1st of June 2022 till judgment, was abandoned by the claimant at the adoption of the final written address stage. However, the claimant is seeking the second arm of the relief, which is for the rate of 15% from the date of judgment till the entire sum is liquidated. The court noted that the claimant did not state how it arrived at 15% interest rate. It is tried that post-judgment interest need not be specifically claimed before it is awarded, since it is statutory and the courts are empowered to award it as it is discretion, at its discretion based on the stipulated rates, and it need not be proved. See Oan Overseas Agency versus Brownwen Energy, citation provided, and Order 47 Rule 7 of the NICN Civil Procedure Rules of 2017, which provides for grant of post-judgment interest at a rate not less than 10% per annum. Reliefs 1 and 2. The court hereby awards 10% interest on the sums awarded in Relief 1 and 2 until same is fully paid or liquidated. I so hold. On this note, issue 3 above is resolved in favor of the claimant to the extent that 10% interest only on the sums is awarded. All awarded sums shall be paid within 30 days from the delivery of this judgment, failure of which it shall attract 10% post-judgment interest per annum. Judgment is entered accordingly. Signed. So this is the judgment of the court.
As the court pleases, we are grateful to your lordship for a well-considered judgment.